Hello and welcome to this module on civil procedure and civil trial. In this module, we'll be exploring various types of civil suits recognized under the Civil Procedure Code, 1908, along with their specific procedures and conditions. Let's begin with summary suits, governed by Order 37 of the CPC. The main purpose here is to offer a fast-track procedure for recovering debts. Think of it as a shortcut designed for quick case disposal, especially when detailed procedures aren't required, helping address the common issue of lengthy civil suits. These suits can be filed in high courts, city civil courts, and courts of small causes, and other courts can also be empowered by the High Court. They typically apply to suits involving bills of exchange, hundies, and promissory notes, or where the plaintiff seeks only to recover a debt or liquidated damages, usually from a written contract. A key feature to remember is that, unlike ordinary suits, a defendant in a summary suit cannot file a detailed written statement without the court's permission. Now, how do summary suits actually work? The plaintiff files a plaint in a specific summary format, and summons are issued in a special form, different from normal suit summons. The defendant must appear in court within 10 days of receiving these summons. If they don't appear, or fail to file a leave to defend application, the allegations in the plaint are considered admitted, and the plaintiff is entitled to a decree, including the principal sum, interest, and costs. To defend the suit, the defendant must apply for leave to defend within 10 days from the service of summons for judgment. This application must be supported by an affidavit disclosing sufficient facts for their defense. This leave to defend is not an automatic right. The court's permission is needed. The court might grant it unconditionally, or subject to terms, like requiring the defendant to deposit the disputed amount as security. If leave is disallowed, the suit is decreed immediately. If allowed, the application converts into a written statement, and the suit proceeds like an ordinary civil suit. Next up are Inter-Pleader suits, covered by Section 88 and Order 35 of the CPC. These are filed by a person, often a stakeholder, who possesses property or money but is unsure about the rightful claimant due to conflicting claims. The plaintiff in this type of suit doesn't claim any interest in the subject matter itself, beyond the costs for bringing the suit. Their purpose is twofold. First, to absolve the plaintiff from their liability regarding the debt or property, as they want to pay or deliver it but are confused about whom to give it to. Second, it helps determine who is the rightful owner among the adverse claimants, who become co-defendants. The subject matter can be a debt, a sum of money, or movable or immovable property. For instance, a bank might receive conflicting claims on the same deposit account. For an interpleader suit to be filed, specific conditions must be met. The defendants must be claiming adversely against each other for the same thing from the plaintiff, and the plaintiff must detail both their contentions in the plaint. Crucially, the plaintiff must claim no interest in the subject matter itself, only their costs and expenses for initiating the suit. There must also be no collusion between the plaintiff and any of the defendants. The plaintiff must genuinely doubt the rightful owner. A restriction under Section 88 is that an interpleader suit cannot be filed if there's already an existing suit pending that could determine the rightful ownership among the co-defendants, preventing multiplicity of suits. Regarding the procedure for interpleader suits, once instituted, the court may order the plaintiff to deposit the subject matter, debt, money, or property, in court, or deliver it to a specified person. At the first hearing, the court has a few options. It can discharge the plaintiff from all liability if the subject matter has been deposited, and continue the suit solely between the co-defendants to determine the rightful owner. Alternatively, the court may retain all parties until the final disposal. If the parties' admissions are sufficient, the court can immediately adjudicate the title. If not, issues will be framed between the parties to determine the rightful owner, and the court can even transpose one of the defendants as a plaintiff. As for the plaintiff's costs, they are entitled to recover the expenses incurred in bringing the suit, as they are not interested in the subject matter. The court has the power to declare a charge on the subject matter for these costs. meaning the rightful owner might not claim the property until the plaintiff's costs are paid. It's important to understand the distinction between Section 88's proviso and Order 35, Rule 3. Section 88's proviso bars an interpleader suit if a regular suit determining ownership between the co-defendants is already pending. Here, the interpleader suit itself cannot be filed. However, Order 35, Rule 3 allows for a stay on a subsequent suit filed by one of the defendants against the plaintiff of an already pending interpleader suit, for recovery of the same property. The interpleader suit continues, but the subsequent suit is paused to avoid multiple proceedings. As for appealability, decisions in interpleader suits are generally appealable. An appeal can be filed against the dismissal of an interpleader suit, and also against the final adjudication, or even specific decisions made under Rule 3, stay of subsequent suit, Rule 4, discharge or retention of plaintiff, and Rule 6, creation of charge for costs. Beyond these specific types, there are several other key civil suits to be aware of. First, injunction suits, detailed under Order 39 of the CPC. Their purpose is to prevent a party from doing or continuing to do an act. They can be temporary injunctions, granted during the case to maintain status quo, or permanent injunctions, a final relief after a full trial. Conditions for granting include a prima facie case, potential irreparable harm, and balance of convenience in the plaintiff's favor, such as preventing land encroachment. Second, suits by or against the government, under Section 79 and 80 CPC. These have special requirements, like a prior legal notice, typically 3 months, and may involve longer limitation periods, as seen in disputes over government contracts. Third, suits by indigent persons, governed by Order 33 CPC. An indigent person is someone who cannot afford court fees. They must prove they lack sufficient means and have a valid cause of action. If allowed, the suit proceeds without fee payment, but can be rejected if frivolous. Continuing with other important civil suits, we have those involving special categories. This includes suits by or against minors or persons of unsound mind, under Order 32 CPC, which require the appointment of a next friend for a plaintiff or a guardian ad litem for a defendant, with special safeguards due to their legal incapacity. There are also suits involving public trusts, Section 92 CPC, which must be filed in the public interest and require prior permission from the Advocate General or the court. Suits involving public nuisance can be filed by an affected person or even by the state, common in environmental matters. Suits by or against corporations or firms, Order 29 and 30 CPC, involve corporations suing through authorized officers, and partnership firms suing or defending in their registered name. Lastly, suits by or against soldiers, sailors, and airmen have special provisions to protect them from proceedings while on duty, such as time bar protections. Finally, within special categories, we also have suits by and against aliens or foreign rulers, which generally require central government consent to sue or be sued, and cannot be sued unless specific conditions under Section 86 CPC are met. Mortgage suits, under Order 34 CPC, relate to the foreclosure, redemption, or sale of mortgaged property. And finally, suits involving constitutional questions. If a suit challenges the constitutionality of a statute or an action, it must be transferred to the appropriate constitutional bench, or the court may frame the constitutional issue separately for determination. This concludes our overview of various civil suit types. Thank you for listening.